of the areas, we understood that this data protection, all of us, we know that hope I'm audible. Okay. So all of us, we know that we deal with lot of personalized data, personal level data, and sometime by virtue of a larger partnership, then also larger association, we need to give it to the other parties. Of course, there is this non-disclosure agreement in most of the cases. It is I mean, in the system, but still we are a little bit careful. You have to be a little bit careful. And this your digital personal data protection law. In many cases, we do not understand that how far can we go, what are the things we need to do. There are also compliances we need to be, I mean, going through. All these things are there. So we thought that this is, we should take this opportunity to learn from legality that what are those areas and how can we do it. Why we do this virtually, because we want to spread this one across country, and not only the very senior people, mid-level people, everybody needs to understand that what exactly is this one, as this is one of the all the this is one of the areas which is uh, little bit in confusion. We do not understand. If we understand, maybe partially we understand. But at the bottom line, we understand that it should not be disclosed. But how to do it? What are the processes? In most of the cases, we do not understand, and we are also not that much educated about the law. So we are taking this opportunity and to present that one. We have our knowledge partner, legality, and I think Mr. Jogesh is there from legality, who will run us through, we will be helping us to understand all those things. So there will be presentation from their end, and then there will be some discussions. So discussions will be Mr. Linson C. Paul. He is Chief Technology Officer of Muthoot Microfinance. We're extremely happy to understand from all three. There are three. Another one is this Ram Thawani from Saman. He is the Chief Information Security Officer, and Mr. Dinesh Yadav, CTO Pahel, he will also be there. So I mean, they are not really the panelists, but they will ask the question. They will share the experience with them. They will share the challenges with us. They will help us to understand and dive deep to strengthen our knowledge. So over to you, Yogesh.
Thanks for the introduction, sir. Good afternoon, everybody, and thank you for joining us for the webinar today. I'm delighted to introduce our host, Pushkal Dubey, who heads the Concern Infra team at Legality. With his expertise and experience in concern management infrastructure, Pushkal will be sharing valuable insights and updates on the latest trends and best practices in this field. Without further ado, I pass the mic to Pushkal to take us through today's agenda. Over to you, Pushkal.
One thing that
Thanks so.
if I can get a minute, there is a request to all of you that if you can write your name, designation, and the name of the institution in the chat box, it will be helpful for us for our this your documentation. Sorry, Pushkal, please carry on.
No problem. Thank you so much, Doctor. So I just have one housekeeping request. I'm not allowed to share my screen in the meeting right now. So can the host please extend
Yes.
that permission to me?
Sangeeta?
Yes, already made you host. Please see.
Okay. Just trying to share. And it says sharing is not allowed. Maybe I'll try to refresh. Okay, got it. Just one.
Till the time we are this Pushkal is prepared, I mean, please do write your this thing. So we are 84, but we have only got the information of 36. So any problem in the presentation? I think Pushkal has signed up and he will be once again coming back. Right, Yogesh?
Yes, sir. He'll be joining shortly.
Hmm. Hmm.
Hi, Sangeeta. Could I request you to give me permission to share again? Uh, I had some issues, so I had to rejoin.
Yeah, done.
Got it. Thank you. Is my screen visible?
Yes,
Yes, yes.
is visible.
Hello.
Yes, Pushkal, it is visible.
I'm so sorry about this. I'm having some issues with Zoom. Hello. Am I audible?
Yeah, Pushkal, we can not just the tab, we can see the complete screen.
Hello.
Pushkal, I think incorrect screen has been shared. The deck screen is not visible. The other screen is visible.
Yeah, that's what I was also thinking.
Yes. I think
Yeah, now it's
now
good. Yeah,
now
yeah.
we have everything.
Right, right.
All right. Took a while, but we got there. Thank you so much for waiting. I think I'll get started right away. So yeah, this session is about a roadmap to DPDP compliance for MFIs. What we are trying to aim for with this session is to provide a practical roadmap, like for the practical steps that you need to take to achieve DPDP compliance, assuming that you start at zero, right? You start with zero understanding or information about the compliance. And there is a special focus on some specific challenges that all of us, so by now have gotten used to and are all talking about these challenges, that the new compliances that bring in new challenges for us to deal with. So we have picked out some of these challenges and had us put a special focus on these challenges in our discussion, right? The way I think we can do this discussion is that I will cover some key topics here, and then we can take a pause for questions, and after that I can go into demo. So I hope that structure works. Quickly, before I get into the structure, introduction, I'm Pushkal. I am the head of consent infrastructure here at Legality. I used to be a privacy lawyer with Trilegal, and I've advised on global privacy regulations and the PDP bill. And now I've been a product manager building compliance products for BFSI. And now I'm heading the consent manager mandate here at Legality. So how are we going to go about it? This is a rough structure for the discussion. First, we will talk about what is personal data and how to find it. We'll also talk about data mapping. We'll go on to talk about assessments and how to carry out risk assessments that will help you identify risks across your entire data mapping. We'll focus then on consent, which is at the core of DPDP compliance. After that, we will move on to third-party risks. And if we have the time, we will also talk about data retention and personal data breaches. Right. So this should give you an overview of the key obligations that are coming out of the law. So without any further ado, what is personal data and how to find it, right? So firstly, what is personal data? So this itself is a difficult question.
The presentation is not visible.
Is it? Okay. Can you see it now?
Yeah, now it's okay, fine. Please.
Thank you so much. Thank you for pointing that out. I hope my screen is visible now, and let me know if there are any issues. So yeah, the first topic is what is personal data and how to find it. And this itself is complicated, right? Because the definition that we have is reproduced over here. Any data about an individual who is identifiable by or in relation to such data. But we don't have any real examples or any way to find out, okay, what is specifically personal data. So this, without getting too much into this specific topic, what is important is we need to make a list of all the identifiers or all the personal data that we are processing that can be considered personal data, right? So that is step one, make a list of all personal data. Step two is, where is this personal data, right? And that is where discovery comes in. So you need to make a list of all the systems that you're using to process personal data. These can be your internal databases, cloud storage, third-party platforms, etc., right? And then what is the type of the database, right? What is the type of the database that is being used by this system? So for example, some systems use structured databases like MSQL, Postgres, Redshift, etc. Others use semi-structured, right? So for example, your JSONs and XML dumps and your CSVs and all of that is semi-structured data. Other data sources, other systems have unstructured data, right? So for example, Google Drive, email servers, these are all unstructured data sources. So the data type is, the database type is also important because specific connectors have to be written for those databases. Once you have identified the database types and you can launch a discovery on those databases and you can identify and categorize data, right? So this is done using pattern recognition and classification models. So you know that when you see a 10-digit number, it's probably a phone number. If you see a PAN format, then that is a PAN number, and so on and so forth. You identify and categorize all the data that you scan across different databases. And then for each data asset, you have to identify the sensitivity, controls, and the risks associated with that data. So Aadhaar, for example, is highly sensitive. The risks are confidentiality risks and identity theft. And the controls can be encryption, tokenization, and data vault. So for each such data point, you can identify these controls that can be put in place. So that is your step one, discovery, right? What does this look like in a workflow typically for scanned KYC documents, right? So you would have some sort of a server where all of these scanned documents are put. You can run discovery on that server, and that discovery algorithm will classify the images and perform OCR on the scanned documents. So where if the images are scanned copies of identity documents like Aadhaar or driver's license or ration card or voter ID, then that classification can be made. And where it is filled out forms, those forms can be converted into text, and any personal data, for example any phone number, etc., in those forms can be identified as personal data. So even if you have a lot of scanned documents in your database, that can also be used. The data discovery can also be carried out across all of those documents, right? Once you're done with data discovery, the next step then becomes to map the data, which is data mapping, right? So data mapping is critical to achieve transparency, control, and minimize your risks, right? It is not explicitly mandated under the DPDP Act, but it is essential to meet DPDP requirements. You can get to it using data discovery, like we offer a consent in minutes, which is a
Pushkal,
data.
1 minute. Pushkal, 1 minute. It's actually, sorry for interrupting. It's here now. It's actually a lot of people are here from various organizations. So I hope the first three slides can be explained little more on a simple mode. Like it's all personally identified data need to be captured and mapping and workflow that I hope you can just simplify it and say a few, ask for some questions also. If anybody can raise few questions, then it will be helpful for them. Otherwise, maybe a little bit on a technical, kind of a thing. It's an input from me. I hope, Saibal, is it okay?
Yes, very much. I agree with you. I was actually
Sure.
about to ask him about, once he finished this one, I wanted to ask him the first three slide to be little bit, this simplified, and people from different levels are there too, so they can understand it. Thank you very much.
Got it. Yeah, I can simplify this. And if you have any questions, we can take a pause to answer those questions as well. But maybe we can have some structured time for that. For now, I can simplify this further. So what we mean by data mapping is simply what systems we are using to process all personal data. What is the activity for which we are using these systems? What is the purpose for which we are using the data? What is the data and who is the principal? Right? All of this can be mapped together to give you this transparency and control over your data. So just to take an example, let's say there is a customer, you collect their email and phone number. Now this email and phone number is used also for lending, right? As well as cross-selling. When you use the email or phone number for lending, you use it for, let's say, KYC, right? And you share it with, let's say, a system like Karza, right? However, when you use email, phone number for cross-selling, you may use it for, let's say, email marketing, WhatsApp marketing, etc. And you may share it with other systems like MailChimp and Gupshup. Now, this data map allows you to understand whose data and what data you're sharing using for what all purposes. And it gives you a complete control over your entire data flows, right? This control is essential to achieve DPDP compliance. So at this point, I'd just like to take a pause for 2-3 questions from the audiences so that I can also get a sense of what I can focus on specifically. So maybe if we can have the first 2-3 questions just so that I can explain further and structure this presentation more. You can put your questions in the chat as well. I can read the chat.
Yeah, Pushkal, it's actually Linson here. It's actually, can you please guide the team regarding all these things? No, it's so initially you discussed about the gap analysis. No, okay. So how they can do all these things? How they can find out what are the gaps related to all these things? It's actually you already mentioned about personally identifiable data. Okay, and from there, it's actually it may be sitting in different sources. How it can be gathered or how it can be notified as a personally identifiable, and also how the consent can be collected, and then only the third party utilities can be used like Karza or Mailchimp or all those things. No, okay. From
Right.
a practical point of view, how you can help them on that. Okay, please.
And also, Pushkal, do you have a slide on what your this law is telling? This your digital
Uh,
personal data protection law. Do you have a slide on it? That okay, fine.
yes.
This is the broad contour of the law.
Sure. Sure. So I think we can move talk about like the broad contours of the law. I'll open a slide on that, and then next we can go on to answer specific questions about the other questions that we got about gap assessment and focus more on consent. Right. I hope that makes sense. I'll just stop my sharing and open that slide about the changes in the law. I hope my sharing is stopped.
Yeah, Pushkal.
Is my screen visible?
Yes, Pushkal.
Okay, great. So yeah, this is answering the question about what changes with the law, right? So I think this we can take it as a first step about the changes that come with the law. The first and foremost change that comes in is that consent is required for processing all personal data, right? Earlier, before the DPDP Act, you needed consent only for sensitive personal data such as financial, health, biometric, Aadhaar, etc. But now you need consent for all personal data and for each specific purpose. So this is critical, where consent has to be collected for each purpose for which you're going to process data, right? So you may process data, as I was discussing earlier, for account opening, and also for marketing. And you need to process data differently for each of those purposes. Similarly, the second requirement is to withdraw consent. Like earlier, there was no clear clarity on the process of withdrawing consent. It was in place, but only in form. But now the process for withdrawing consent should be as easy as providing consent, which is another new requirement that has come. Sharing information is critical. So earlier, there was no need to monitor third parties once data is shared with them, right? You could just collect all the consent in one go as a blanket sort of acknowledgement or as part of the account form. And then you could share the information with all the third parties that were part of your pipeline. But now you need to ensure that you are sharing data only where consent is available, right? So for example, if you don't have consent for marketing, then you cannot share the data with the vendor that you're using for marketing, right? And secondly, if consent is withdrawn, then you need to make sure that all the vendors delete the personal data whenever consent is withdrawn, right? Which becomes another requirement about sharing of information. So now your data sharing needs to be controlled more actively, right? And this is where the data mapping that I was talking about earlier also comes into play. Auditability is a key requirement. Earlier, there was no need to maintain any records of consent, right? But now you need to maintain verifiable records of each notice and consent, right? Earlier, there was no real right to access your personal data, or erasure rights were not clearly defined. Now there are clear right to access, erasure, nomination, and all of these new rights are created. That means that the customer can come to you and say, give me access to all my personal data. And you have to provide them all the personal data that you're processing about them, all the third parties with which their personal data is shared, and all the activities that are done with the personal data. So that is a very critical right that they can claim from you. Similarly, they can come to you and ask for erasure, and you have to erase all the personal data that you're not using for a legal purpose, right? Enforcement is a big change, right? Earlier there was no governing body, no enforcement, and now there is a data protection board that has been formed with a clear power to enforce fines, and these fines can be up to 250 crores per violation, right? When it comes, and these fines start from 50 crore per violation to 250 crore per violation, and that is for each instance of violation, right? So this can really quickly add up, and these are so far the highest fines that we've seen in any law, right? So that becomes a massive risk. Any mishandling of data, any breach, or any such process with personal data becomes a massive risk for your organization. Personal data breach is also has also gotten some additions. Like earlier, there were sectoral regulations, RBI norms, etc., that would govern breaches, and you had to make notification to certain as well as RBI. But now there is also data protection board who has to be notified. Furthermore, you have to notify all the customers or the principals or the end users who are impacted by this breach, and you have to notify them, deal with the queries and questions as well. So that creates a massive overhead for you while you're trying to deal with the breach and mitigate for the breach. You also have to notify all customers and deal with their support requests and their requirements and help them out as well, right? Data retention is a big thing that has changed. Earlier, data retention periods were prescribed in sectoral regulations. For example, KYC data or transactional data has to be stored for a certain period of time. And that would be used as minimum sort of data retention periods in organizational policy. So if you within your organization, if you have a data retention policy, the RBI norm will be used as the minimum period for your data retention policy. Now, the DPDP Act says that if you don't have a purpose for which you're going to use the data or a legal requirement to store that data, then you must delete it, which means a delete by default requirement. And therefore, these legally mandated periods have become the maximum periods for which you can store personal data. And that also means that you have to maintain a data retention policy. You have to be able to track, when a business relationship is being closed, when an account is being closed. And based on that, you have to keep the data for the retention period. And after that, you have to ensure that that data is deleted. Where there are no retention requirements, for example, credit information, etc., there you have to delete the information after the business relationship is over or if the purpose is completed. So so that retention is a big change that has come in. And again, children's data is a special requirement for disabled persons, right? You have to collect consent from a verifiable parent or guardian, and you have to be able to verify the identity of those parent or guardian. So this has entirely changed. Earlier, there were no such special requirements, right? So this is what has changed before. Like these are the changes from before and after the law has come in. Now, I would want to go and talk about collecting consent specifically. And after that, I will show you a demo. There were a bunch of other topics that I wanted to touch upon, but I think we can keep it short and keep it focused on collecting consent. But while I set up my screen, are there any questions or inputs before I get into the consent piece?
Hi, Pushkal. See, consent, definitely we will be discussing on that. But maybe prior to that, the data discovery of the different repositories, maybe if there is any tool that need to be shared, or if any information, so that the audience will be aware of it.
Right. So I touched upon data discovery. So we at Legality, we are working on consent in Lens, right? We have a data discovery tool And using the data discovery tool, you can, and data discovery is the first step in finding personal data. So using this data discovery tool, you can find out what personal data is sitting in which system. So I touched upon these parts earlier. I will just quickly go over them again. The first part of data discovery is, what systems. First part is to list out all the personal data, all the all the in data that you're collecting that can be categorized as personal data. So name, phone number, email ID, IP addresses, Aadhaar, etc. would be these itemized personal data, like these list of personal data. The second step is to identify what systems you're using to process personal data. This can be your internal database or cloud storage or third-party platform. Then you go on to identify the types of databases. So databases can be structured databases or unstructured databases. They can also be semi-structured databases. So based on the various types of databases, we have connectors for each of these types of databases that are available in our application. All you have to do is you have to scan your databases using our application. And once the scan is over, at the end of it, you get a list of all the identifiers that are sitting in these different databases, along with the file path of those identifiers. So this process is typically called data identification and categorization, where after scanning all your database, we tell you, okay, there is a phone number, list of phone numbers in this particular table in this database, or there's a scanned copies of Aadhaar and PAN card that are in this file server, etc., etc. So at the end of this process, you get a list of all the personal data that is available in different locations in each of these databases. And then for each of those personal data that you have identified, you can define your controls, that are required. So for example, for Aadhaar, you can use encryption, tokenization, and data vault, etc.
Right. So this will be very useful when actually if there is an forget data request is coming from the customers, then it will be very useful to find it out the data where or the data which is located into different repositories, so it can be deleted accordingly.
Yes, absolutely. So it is very useful for your erasure request because you need to know where the data
Where
is to
it
be
is
able
lying,
to
yeah.
erase it. Yeah. And when it comes to scanned documents like Aadhaar, PAN card, etc., it is impossible to know because you would just have a repository. So DSAR, which is data principal rights, like an erasure request, basically, it is super duper useful, but also it is useful at a more preliminary level to even begin to map out your data and to begin to use consent, collect consent, and use data based on consent. You need to first identify where the data is, right? Then you can take steps to minimize the data or provide control to the end user. But the first step is to know where the data is. So data discovery is useful for that as well. So once you have discovered your data, you get to data mapping, and I think we covered this data mapping. And I'm going to skip this assessment part and get to consent. But before I do that, I'll just take one more question. If there's any specific part about maybe the changes in the DPDP law or any other thing that you want me to touch upon. Are there any more questions?
Pushkal, there are 2 questions in the chat box.
Okay, I'll just look at that. How can one ensure that data is deleted once the consent is withdrawn? What will be the retention timelines to retain the data or erase the personal data? All right, sure. So I think I'll take these 2 questions, and I think these questions I'll be addressing in the next bit. So I will be able to answer your questions about retention timelines and how to ensure that data is deleted as I talk about consent, right? So I will dive straight into the consent, uh, bit of things. Now, when we talk about consent, what are the requirements for consent? Right? Like that is first step. So these requirements that you're seeing on your screen, they are, they come from the law. So you have to collect granular consent. You have to give clear and understandable consent notices in local languages. Consent withdrawal must be easy. If consent is withdrawn, then you have to ensure that data is not processed, and you have to give verifiable. You have to maintain verifiable records of consent. So these are all the requirements. The key requirements here are the notice, right? The notice must contain an itemized description of your services. It must contain a granular description of the purposes for which you're going to process personal data. You must describe what data is going to be processed, and then some other processes need to be there: how to exercise rights, how to make a complaint, right, to the board, a contact number of a DPO or such other person within your organization. All of these things have to be put in a notice, and the second step is to collect consent against that notice. Now, this is a problem when in the MFI context. Hello, I think there's some disturbance in
There is a
the.
request if anybody is not speaking, if they can put. Yes, thank you.
Thank you so much. So, when we look at the MFI context, like these requirements are very simple. When you have a web journey or an app journey where a pop-up comes in, and you just provide your consent. But when you look at the business of an MFI, you have to collect this consent in very difficult conditions, right? So you have to collect consent in conditions where there is no internet connectivity or unreliable internet connectivity. The borrower lacks access to a smartphone, maybe, right? The borrower is comfortable only in their local language, and there are low literacy levels, so people are not even able to read the notice as well, right? So in these cases, you can still solve for it by assisted flows, right? So if the customer is physically present in front of you, you can collect consent through an agent's device, and our pop-ups consent notices can be integrated in the application, in your origination application, and you can collect OTP to uniquely authenticate and uniquely identify each customer. So the agent device, backed by an OTP, can be used to collect consent using an assisted flow. Now, this is something that I will demo to you right after we are done with this section. So you'll get a very clear idea of this, right? And if internet connectivity is a problem, you can do this even using an offline flow, right? Now, this is the ideal way to collect consent. Because this allows you to collect consent before you do anything else with the data, which is the requirement under the Act. But it can happen sometimes that the customer is not present when the data is first digitized, when the data is first entered into any application or anything like that. In such cases, the first step has to be to trigger a consent request, right? And consent requests can be triggered through even an IVR message, right? Where a customer will be informed about all the things that I listed out earlier, and then they will be able to say yes, no, or ha, na, or provide vernacular sort of consent for each different purpose for which their data will be used. Of course, some purposes are optional. So, for example, for onboarding, KYC, etc., credit check, etc., would be a mandatory purpose, and that you cannot really refuse consent for KYC. But some other purposes are optional, right? So, for example, your improving your like credit modeling or marketing or stuff like that, cross selling. These can be your optional purposes. So for optional purposes, the customers can provide their consent even to an IVR if they were not present when they first submitted the form, right? The often so far consent has been collected as part of the account opening form itself, right? So sometimes there is a paper form and the consent language is added in the form, and the customer just puts a tick mark or something like that. Now there may be some bias towards using these paper forms to collect consent right now as well, like put the notice on a paper form and collect consent on that notice. While that can act as a proof of consent, like a paper form can act as a proof of consent, it is not the best way to digitize your consent. Because at the end of the day, all the consent that you're collecting has to be digitized. And after being digitized, it has to be used for governance. right? What data is being shared with which system, that is determined based on consent. So this data on the physical form has to be digitized. Now, when you upload a physical form and scan it and then upload it as a proof of consent and then digitize it, that involves OCR and all of that, or manual data entry, both of which create chances of error, right? And each such chance of error creates a risk on your business. So that's why physical forms is the least, while you can technically use that as a proof of consent, it should be the least preferred way to collect consent from your customer, even if the customer is not present. So another associated with consent collection is also data principal rights. So these include access, correction and update, erasure, grievance redressal. So I've touched upon these when I was talking about, what changes in the law. So you have to allow the data principals to be able to exercise these rights as well. It can be enabled in the same way consent collection is enabled, right? So if it is happening at a branch, it can be integrated with the branch application. If it is happening on an agent device, these flows can be integrated with the agent application, right? Now, all of these different rights have, different sort of impact associated with them in access. As I mentioned earlier, you have to give access to the customer to their personal data. When it comes to correction and update, they can correct their data. Erasure, they can ask you to erase some data that you don't need anymore. And grievance redressal means, you have to redress their grievances. Now, this part helps you understand, okay, how do I collect consent, right? But that is the first step in the life cycle of the data. After you have collected consent, you share that data across multiple systems, and a lot of these systems involve third parties as well, right? And that creates a lot of third party risks, right? Now, when it comes to these third party risks, how do you ensure that these third parties are processing data in the right way, right? So that is where your data mapping, which I was talking to you about earlier, that is where that becomes super important. The first step to minimize third-party risk is to do a privacy assessment of your third parties. This is something that you're going to have to do, that you already have to do as per your RBI requirements, and there will be just more requirements that will be added to these assessments, and you'll have to do with all third parties that are processing personal data, right? The second step is to do mandatory consent check. Before you're sharing any record with any third party, you have to check the consent database for if consent exists to share that data with that third party, right? If consent exists, then you can share the data or the third party can perform the operation. If consent doesn't exist, then they should not perform that operation. This requires consent check APIs and consent master databases to be integrated across the various customer touchpoints in your system, right? The third thing, and this is an answer to the question that was raised in chat. You have to automate deletion instructions to third party, right? So if a customer comes and withdraws consent for marketing purpose, right? Now there are some third-party systems that you're using, or some internal applications also, as well as some third-party systems that you're using for marketing purpose. When this customer has withdrawn their consent, you have to send a deletion instruction to the third party for deleting the data of that particular ID. And that can be automated using a software like consent infrastructure, right? And these automated deletion instructions can then be verified by the third party. So once the third party has verified those instructions, we store a log of that. And this log helps you ensure that you are not processing data where consent is withdrawn, and any risk associated with that processing can be negated, can be reduced, right? And at the center of this, which is the fourth point, you have to maintain this data mapping. None of the erasure, access, consent check, or automated deletion, none of this would be possible if you are not maintaining a mapping of what data is being sent to what system, as part of what flow, and what purposes is it associated with. Which is why your data mapping that we discussed in the initial bits of this conversation will also help you ensure that these third-party risks are managed properly, right? Now, I also want to touch upon data retention, because that is the last step of your data lifecycle, right? When when do you have to delete your data? And that was also a question that was raised in chat. So that's why I want to cover this part. Now, data retention can be based on legal requirements or the purpose for which it is collected, right? So let's look at both these examples, right? So let's say for the purpose of account opening, you collect KYC data. You collect data for KYC, execution, and credit check, right? Now, KYC has a different retention timeline that applies to it under RBI guidelines. Similarly, execution has different retention timeline that applies to it under ASP guidelines or limitation, right? Credit has no specific retention. Credit data has no specific retention timelines. It has to be based. It has to be. You don't have any sort of legal purpose to store credit data, right? So now, for each of these purposes, processing activities that you're doing, you have to define the retention event and the time period after the retention event for which you're going to keep the data. For example, in a lot of these cases, the retention event is close of business. So, for example, in KYC, after account has been closed, you have to retain the data for 7 years, 10 years, whatever the requirement is, right? In other cases, for example, credit information, there may not be any such legal requirement. In that case, this data has to be deleted as soon as the account is closed, which is close of business, right? The account-based relationship is closed. This is not the case in something like marketing, right? When it comes to marketing, let's say if you're storing credit information for the purposes of marketing or using it for the purposes of marketing, if somebody withdraws their consent for marketing, then you should delete that information in any marketing system, right? So, so that is the difference. That is how you can balance data retention based on the consent to purpose as well as based on the legal requirement. And again, you will notice here that data mapping your each of the processing activities that you're doing to each of the purposes is critical to achieve this data retention in the way that is required under the law. So again, I will take a pause here. In the next step, I will show you a brief demo of a consent collect and raising request journey, and we can take more questions in that meantime. So, any questions so far?
If you have any question, please do ask, because this is a time when we can get the clarification and understanding on the things.
Mainly, no, Pushkal, it's mainly the consent can be, in future, after data discovery, no, the consent need to be a major part, correct?
Yeah, consent is a major part of it. Consent is at the core of your DPDP compliance, because you need to give that control to the principal.
Yeah, and it's
But there are
retention.
a lot of other requirements that come in as well.
Correct. Retention and third-party integrations are very much important here, correct?
Yes, yes.
Okay. That may be the takeaway from this session, correct? It's actually, especially, and also one more question I'm having here, the DPO, what may be the DPO role and how important, and then how he need to be, contacted with the board, DPDP, that data protection board will be there, no, from the government side, correct?
Yes, yes. So the DPO is the owner of all the all the privacy compliances in your organization. So when we talk of privacy compliances, there is third party assessment, privacy impact assessments or PIAs, right? There are transfer impact. There are different sort of risk assessment basically that has to be done with additional requirements from a privacy perspective and not just from an information security perspective. Then you have to make sure that any data subject access request, like for example, if any customer comes to you and asks for right to access or right to erasure, then all of those requests have to be handled centrally, right? So that is also something that is also a function that is performed by the DPO's office, right? Similarly, just ensuring that there is enough coordination across, IT teams and legal teams and procurement teams, etc. From and with the privacy sort of KRA in mind, that is the function also of the DPO's office. So that is how the DPO's office helps you meet your DPDP requirements. They are dedicatedly focused on incorporating data protection compliance across all your internal as well as external processes of your organization.
Pushkal, the question is, for example, there are different platforms available, right? For example, if we have to do anything with RBI, we have a Daksh portal, right? Similarly, there is a DOT portal available where we communicate with this regulators. Okay. So similarly, if this DPO he has to communicate with the data protection board, is there any medium available?
So not as yet, but that is the idea under the law. The idea under the law is that the Data Protection Board, the DPB, is going to function as a digital office, and there is going to be a portal for you to interact with the DPB as a data fiduciary, who's someone who controls the data, and there's also going to be a portal to interact with for the customers, for the data principals, also to interact with the Data Protection Board. So the act says that the Data Protection Board is going to function as a digital office. So an online portal is definitely going to be there for the Data Protection Board.
Okay.
That significant fiduciary, that term, how we can define actually for each and every NBFC or MFI, how it may be, maybe a critical criteria, anything is there? Or-
So significant data fiduciary, the criteria is set out in the law about, what is the volume of the data that is being processed, or how important is that organization for, what technology is being used. So there are different criteria that is set out, but there is no clear list that the government has given as yet for significant data fiduciaries, but there is informally they have mentioned in different consultations that large regulated entities are going to come under the ambit of significant data fiduciaries.
Okay.
Right, Pushkal?
What about that number or any idea on that?
No such hard guideline is there.
Okay.
Pushkal, any clues on this digital lending perspective, like the face and the biometric on the face or the voice, because all those are also considered as a data in context of this digital lending. So
Right.
whether this data production has any views on that?
Yeah, definitely. So if you're all of this would be in the digital context, all of this would be personal data, and all the requirements that we are discussing about personal data would also apply here. In fact, the examples that you gave, which is biometric, is highly sensitive personal data,
No,
and that's why
not
it has.
no. I take it back. Not biometric. I'm referring to specifically on the face and the voice.
Yes, these face and voice can be used to identify an individual, and that's why they are personal data. And so you have to, all the requirements that we are discussing will apply to face and voice as well.
So this DP Act has something explicit on that?
No. So the Data Protection Act has not, the DPDP Act has not explicitly called out any data as personal data. They haven't given a list that, okay, these identifiers are going to be personal data. So it's really upon, all they've given you is a definition, which I flashed earlier. The definition is any data that can be basically an individual is identifiable in relation to that data. So now any data that can be used to identify that individual can be considered as personal data. So the definition is any data about an individual who is identifiable by or in relation to such data, right? So that definition is broad enough to cover any data point that can be used to uniquely identify that person.
So my worry crops out from the fact, in terms of the lending business, as we are seeing, there are a lot of advancements going on the BRE, the rules engine, and specifically based on this, machine learning, all these algorithms, if you see, they are mostly focused on getting into some or other data. Okay. Even whatever data is not explicit, they are converting that into a data. Okay. So my voice and my face was actually the example of the same thing. So my worry is that whether this DP Act would be able to address all those risks which are actually cropping up from these ML things, AI and ML things.
Yeah, absolutely. That's a very valid and relevant questions, and I think that is why the definition has been kept so broad. So at the time of writing the law, the legislator, the lawmakers, they don't know what all you can use to identify an individual, right? If you give enough traits about somebody to an AI like ML or algorithm, they can identify them to a very scary degree of specificity, right? So, which is why the definition of personal data has been kept broad. If if you're creating data points like cookies, for example, that are being used, or any other digital tracking technology that you are using to uniquely identify an individual, then you have to treat it as personal data, right? So what does that mean in the context of your question? If you're using ML algorithms to use data points that were earlier innocuous, that were earlier not identifiable, but because of the technology that you're using, they have become identifiable, you will have to treat them also as personal data. Does that answer your question?
Yeah, fair enough. So, if I interpret you correctly, so there is still some gap between the whatever is happening. But yeah,
Yeah,
fully.
and purposely.
Yeah, yeah. Thanks.
Purposely, the definition has been left purposely ambiguous. Like that is to make sure that it is focused on the intent, right? And it is focused on the outcome and not just specific identifiers.
Absolutely. Thanks, Pushkal. That helps.
Thank you for that question. That also helped me shed light on one topic. I think there are some interesting questions. Yes.
Hello. Pushkal Shashi of Microfinance. In your data protection slide, I see one of the point as execution and its retention period is 7 days after COB. What do you mean by that execution? Is it,
by execution, I meant execution of documents, and the retention period is, I think, 7 days after the document has been signed. So it wasn't COB, but that comes from ASP guidelines under the IT Act. So that was just an example.
But won't it be required for audit purpose later on if the documents are deleted? So do you mean documents as in the loan document in the KYC or anything? Then it will be required for audit purpose if the loan was sanctioned correctly or not. And what about that?
Yeah, absolutely. You will have to retain records of that for a longer period. You will have to maintain records of executed documents for a longer period after the deletion has come in. You're right about that. I was talking in the context of as a third party, the retention timelines that would associate. So those were generally just examples that I use, not to get too specific about the exact retention timeline. So the exact retention timeline for an executed document would be defined by your RBI obligations, or if there are no obligations, but under the Limitation Act, and you would definitely have to retain it for till the close of business, and after that for some sort of time period till the limitation or till the legal requirement comes in. And this would apply to KYC also, but at the same time, something like a credit check does not have like a credit model or credit information does not have such retention obligations. So when those retention obligations are not there, then you have to delete it in a reasonable time after close of business. Similarly, when it comes to marketing, something like an email, phone number that is being used for marketing, there is no retention requirement for it. So as soon as consent is withdrawn, you should get it deleted from the third party that is using it for marketing. But at the same time, you have to retain the name and phone number, right, for other purposes, which is why it's helpful to have that granular mapping. That is the point that I wanted to drive across.
Also, this consent withdrawal, so some of the mandatory consents cannot be withdrawn. Like if the customer has consented to taking the loan, then automatically KYC, CB check, and everything is like that cannot be withdrawn. That's the correct understanding?
Exactly. That's accurate. That's accurate. So I will show you an example of that in the demo as well. Yeah, very quickly to go over some questions in the chat. What will be the, so there is one, just 1 second. In case a loan is not sanctioned, till how long the information can be kept? So this is one key sort of info. This is a commonly sort of asked question in that we get. So since the loan is not been sanctioned, there is no account-based relationship that has been set up. And since there is no account-based relationship, you should not retain the data that you took for sanctioning the loan. However, at the same time, let's say something like a name or phone number that you're using to inform the customer about your products or something like that, that can be retained. And until, of course, the customer withdraws their consent with you, right? And you have to give the customer a portal to withdraw that consent. So that is like so even if you have not onboarded the customer to given them an account, they still have to have a preference center where they can withdraw their consent, and that is something that you have to provide them. Another question was, if you have submitted the data to credit information company, then if consent is withdrawn, can you delete the data from the credit information company? No, because the data is being shared as part of a legal requirement under the Credit Information Companies Act, and that's why that is separate from this deletion requirement. That applies to optional sort of data categories. So with that, I will jump into the demo and quickly try to show you a simple consent collect experience. I think we're also running out of time. So I want to leave the rest of the 10 minutes also for some question answering. I hope my screen is visible.
Yes, it is.
Okay. So this is just a demo sort of environment that is set up, which will tell you just 1 second, which is basically meant to mimic your application that is running on the agent's device, right? So when the agent fills out a form for a user, the first thing that they will receive is this screen to get an OTP, right? And the principal's phone number has already been entered in the form that has been filled, and then they can click on get OTP, and the customer can provide their OTP. This will help you uniquely identify the customer on the agent's device, right? So if you are already triggering an OTP to the customer, then this can be optional, right? Then you don't need to do this OTP. In the same session, you can collect the consent, right? But if you're not authenticating the customer, or if you're not already using an OTP, then you can use this OTP service to uniquely identify the customer. So that is up to you. In consent, and we provide you both the features. Now,
so you're saying that the same OTP that we are using for mobile verification can be used for consent capture as well?
Yes. As long as you're collecting the consent in the same session, it's up to you. Basically, if you want to use consent to authenticate the customer, or if you're going to authenticate the customer yourself, as long as the customer is being authenticated, and this consent can be attributed to that unique customer. That is the only requirement.
So is it the same session or the same screen?
Same screen. By same session, I meant the same sort of, basically the same authenticated session. So in the same screen or in the same flow even. So it doesn't have to be the same screen. It can be the next step in that screen. That is also fine. But before that, you have to have uniquely authenticated the customer. So this notice you can see in across all of these.
Pushkal, what about the data storage part?
Could you elaborate a little bit?
Yeah, because no, it's actually the consent will be working on your platform, correct?
Right.
This intermediary application will need to be integrated with each and every MFI's application, correct?
Yes, you will integrate our SDK. Yes.
Yeah, it will be sitting in between application, correct?
Yeah.
So automatically the workflow will be automatically guide our or push our data to your platform, correct?
Yes, absolutely.
Then automatically it will come to your database.
Yes.
Then one copy of our data will be sitting in your DB also.
Yeah. So this is the just to make a differentiation there. There is the consent data, and then there is the rest of the personal data about the person that you're collecting. Right. Now, the rest of the personal data will not come to us. Right. The rest of the personal data will go to you. There are no changes that are being made in that pipeline. It will be stored in LOS or in your origination application the way it is happening right now. Right. But when it comes to the consent data, that is the data that is sitting in our system, right? And within that consent data, we have designed it in a way that we can be data blind. So if you, so this is just a mock-up of the form that is being filled and the API call that is being made. So here you see this, field called principal ID, right? So all we need is this principal ID from you, right? And this ID can be an application reference number or a temporary ID or a customer ID. It depends on the workflow, but we are storing only this ID, right? Here you see that the only other identifier I have entered is a phone number, and the only reason I've entered the phone number is because I'm using OTP for this flow, right? So when I'm I need this phone number to trigger an OTP to the customer. If this OTP was not enabled, in my previous response, I mentioned that you can use it without an OTP also. If this OTP was not enabled, then I would not have to enter this phone number also, right? So the phone number is also optional. So the only data that is actually being stored is just this principal ID, which is which by itself cannot identify any individual. It needs to be referenced or related to your database, which is separate from us, to be able to identify anybody.
That means you are not storing any personally identifiable data in your DB.
Just the ID, just your ID, the ID that you are sharing.
Any references need to be put in our records related to this one. The principal ID need to be stored in our database also. Then only it can be mapped. Correct.
Yes. So that is the ID that you should use, the ID that you're already using. So for example, you would be using an application reference number or some such ID to identify the borrower, and that is the ID that you can seed with us at the time of consent collection. So yeah, as I was saying, you have the notice available in all of these different languages as well. And if in case the borrower is illiterate, we are also adding a text to speech here. So the notice can be read out to the borrower. In case of an IVR also, this notice can be fed to the borrower, and this intent about yes, no can be collected in an IVR conversation also, right? And this notice is compliant. You can put and fully configurable. So you can add all your branding and colors and all of that. So using this flow, you can provide your, you can collect this consent, and this tracking ID is also given. So you can store that also in your system as well, right? And if the customer later comes to you, comes to the agent and asks for, updating their consent, that can also be done. So for that, you use our update API. And just one second. So for that, you can use our consent update API, and you open the preference center, right? So the preference center, so this is just a random ID that I have entered. So this will give you an, like all the various consents that are collected by the customer can all be listed out in one place, and all the records of those consent along with the, consent artifact and all the other details, the customer can also download a notice, download the record, etc., and they can update their consent and save their preferences. So once this consent has been updated, it can be stored on our system. And on our system, you see all of these records that are created, right? So these records, as part of these records, you see all the consent that is granted, as well as the data mapping that we were talking about, which tells you, okay, so this customer's data is being used for all these purposes. All this processing is happening on the data. All these systems are using the data, and all of these, data categories are being used. So this data mapping is stored. This data mapping, which I was mentioning is critical, is stored against each record that is created, right? And this same API can also be used to collect requests from the data principal. So for example, if any erasure is required, I can raise that request using this form, and this form can be hosted online or on your website, or it can be hosted again inside your application. And I will just once I provide this email OTP, I can just one second, I'll just do that. So I can raise this request. Once this request is raised, it ends up in our request record system. So here, all the consent records associated with this ID are all listed out here. So you get the entire sort of history of this particular customer. And you also get to see all their, what all data is being used of the customer. So what all third parties are using that customers, which data is being used by what all third parties. That you can see, and what all processing activity is happening on what all data. All of that also you can see. Then there is a workflow in place where you can, do your verifications and approve the erasure. So once you approve the erasure, an automated erasure instruction will be sent to all of these systems to erase the personal data. And this can be tracked. So once this erasure instruction is shared, this can be tracked using our systems module, and you can see where all erasure is pending and where all erasure is done. Right? These are triggered automatic. These erasure instructions are triggered automatically when a user withdraws their consent as well. So that is another sort of automation that I was discussing earlier as well in my presentation, and that can be used. We have a lot more features, like we have an entire discovery application called Consent in Lens. We are building out for assessments as well. Data privacy impact assessment, privacy impact assessments, third-party risk assessments. So there's a lot more features that are there in this application, but I think for the paucity of time, I will stop here, just focusing only on consent for the sake of this demo. And I think we have some 10 more minutes in the scheduled time for this session. So if there are any questions, I'll be happy to take them.
Any more questions, please? Anybody?
Hi, Pushkal. Actually, Maya here.
Yes, hi Maya. I can hear you.
Can you just summarize this entire session in 2 lines? Because I actually joined little late. So I joined around 3:25. So I understood, but can you just summarize the starting part?
Um, sure. I think it'll be very difficult to summarize the session in 2 lines, but essentially but we'll be happy to share a recording with you as well as the presentation that we showed. We basically discussed all the compliances that arise out of the DPDP Act and what is a practical sort of roadmap to achieve those compliances. Uh, we focus specifically on consent and data retention and data discovery in this presentation. There are a lot of other challenges also, which we can perhaps take on in a later discussion.
Sure.
Pushkal, is there any mechanism which we can use to, so that we can take it, for example, if the data is shared to the third party, and if third party, if they are deleting at their end, we can get some sort of the confirmation, we can record it.
Yeah. So there is a verification mechanism. The third party can manually also verify that this data is done, or they can verify it using an API also. So we have that built in as part of our third party module.
So in that case, we have to extend the APIs to them also, right?
Our APIs will be exposed to them for the data deletion. They can integrate that API. If they don't want to integrate or they are unable to, they can manually come to our platform and log into their profile, and they will see all the deletion instructions and they can delete the data.
Okay. But unless and until the mapping is done at our end, we will not be able to send them the deletion request, right?
Yes, absolutely. Mapping is critical for any of this to work, which is why in the beginning of my session, I spent a lot of time just stressing on, how critical mapping is. It is the most important thing that you need to do, like you need to arrive at. And, yeah, mapping is critical for you to achieve the goals of this app.
Right. That's why actually I was trying to emphasize on that point. Yeah.
Yeah. Yeah, I wish we could have gone deeper into mapping and each of these sort of topics. And I think there were some issues with structure, with the sharing and structure as well. But I hope we were able to, the topics that we did choose, I hope we were able to bring clarity in those topics.
Yeah, Pushkal, I hope that you have covered a good part of this thing. The DPDP Act and its related activities need to be taken care by the organizations. But no, it's actually the participants may be very much eager to hear that where from we can start and what may be they have to prioritize. No, how can you please guide all of them on that, please?
Right. So if you are starting off right now, the first step is to do a gap assessment. Is to look at what controls you have in place right now, and what is the requirement under the act. That will tell you the gap, the specific actionables that you need to perform in order to become compliant with the act. Also, while you're doing your gap assessment, if you can also get a overview sense of your data mapping by doing interviews with department heads. So that is the first sort of step that you can take towards becoming compliant. From there, you'll get a clear idea, sort of flow of all the rest of the steps that you need to take. So I had structured this presentation in that way. So the step one would be, discovery. Step two would be doing your assessments, and step three would be doing your data mapping. And finally, once you're done with your data mapping, you can enable consent, you can enable exercise of rights, and you can manage your third-party risks on an ongoing basis. And then finally, towards the end of the data life cycle, you have your data retention schedules that can be incorporated. And all of this, for all of these activities that I'm listing out right now, you can use consent infrastructure to help you in achieving these outcomes. So we have dedicated modules for all of this, and we'll be happy to sort of walk you through this entire journey. And of course, in cases of breaches, you need a workflow to manage those breaches. So all of this is structured in this presentation as well. We'll be happy to share that presentation with you, and you'll be able to get a better grasp of it. Today, we focused on specific topics so that we could go in depth and discuss them in greater detail. But in this presentation, you'll see an overview of all of these topics.
मतलब तुम्हें खुद से स्टडी कर लेना
आप मेरे को भेज दीजिएगा
So that's all from my end. There's a QR code that is flashing in front of you.
There is one question, Pushkal. If the customer is illiterate and produces digital consent letter is received from them, is there any option to upload the document in the system? So can you please write?
Yeah, we have that option. We have that option to upload the document, but I touched upon this earlier. If the customer is illiterate, there are other ways to collect their consent, such as using OTP or using the agent application or even using IVR. And all of these allow us to create a digital record of the consent. You may upload the physical copies in the application. That feature is available, but it is also a risky way of collecting consent. So it is not the most preferred way of collecting the consent. Even if the customer is illiterate, they can interact with an IVR or interact with an agent. So those approaches should be preferred. But if there is no other alternative available, then yes, a paper form can be used, and we do provide that feature. There is another question, I think, in chat about DPDP Act was effective from 23. Then how is it getting importance right now for MFIs? So DPDP Act came out in 2023. However, it hasn't come into effect. And over 2024, there has been a lot of consultation that has happened. And with the start of 25, we've had the DPDP rules, draft rules that came out. Also, RBI, SEBI, and all these other regulators have stressed upon DPDP compliance as part of their recent directions to regulated entities. So we expect that this act will come into force in the next session of the parliament, where the rules will be released, and then there will be a timeline that will come in place for implementation. This implementation is when the act, at the end of the implementation period, is actually when the act will come into force. But there are so many steps required for this implementation that it will take you a very long period to implement, which is why it is relevant right now, and you need to get started right now.
The act has not been effective yet.
Yeah, the act has been notified by the parliament, but it hasn't come into force. It hasn't become
Like
the law of the land.
it is not a mandatory one.
It is not mandatory right now. It will become mandatory soon. So, and in order to comply with the act, you need to do a lot of implementation, which you have to start right now. So there'll be a timeline given with the act. There'll be a timeline given when the rules come out for you to become compliant. That timeline will be something like 18 months or something. And that in that period, you're supposed to become fully compliant with the act. And then finally, the act will kick in. And then at the onward, you will have to comply fully with all the requirements that we discussed today.
Okay, fine. Thank you.
Okay, so I think we all your questions have been answered for now. We can have more questions, and we can have another session if required, if you have more questions, right? And we will circulate the PPT, whatever is presented out here. So thank you everybody for having joined the session. Thank you so much for your questions. Thank you, the panelists, for asking the relevant questions. Thank you.
Thanks a lot.
Thank you so much. Thank you so much for having us.
Everyone.
Thank you. See you.
Thanks, Muskil.